March 9th, 1978, this man, Jack Jones, 51 years old and unemployed, shot and seriously wounded another man in a decaying hotel in downtown Seattle.
I shot him because I was scared he was going to kill me.
The man Jones shot, Raymond Collins, also known as Big Man, is in critical condition at a local hospital. Jones is charged with assault with intent to commit murder. If found guilty, he could be sentenced to 20 years to life in prison. The court has appointed 2 lawyers to defend Jones. Sarah Lytle.
Now, up to that point, had you at any time intended to kill Big Man?
David Allen.
You have to put yourself in Jack Jones' shoes.
It looks like an open and shut case. His statement to police quotes Jones as saying that he not only shot Big Man, but that he meant to kill him.
I was careful in how that statement was taken.
Dennis Nolet will prosecute the case for the state.
You were pointing that gun more or less right at him when that shot was fired. Isn't that true?
The trial will be presided over by Judge David Sokup.
And I simply am not going to allow this to turn into a trial where you try to convince the jury that the victim was a bad person.
2 of Jones' friends witnessed the shooting. Connie Gardner.
Jack jumped up from the radiator where he was sitting and took the gun out of his pocket.
DeCarlo Myers.
Did you see where the bullet went?
No.
The case is further complicated by the fact that in his statement to the police, Jones admitted shooting another man the day before the confrontation with Big Man. When Jones was arrested, he was drunk.
Mr. Jones? Sir? Huh? You don't understand. You're taking too big of steps. I want the heel and toe touch every time like this, see?
Where you want me at now? You want me right here, right?
That's fine, sir.
Now what you want me to do?
Okay, once you take your right foot...
You mean like that?
There you go, but touch the toe. Touch the toe with the...
No, I can't do that. I got bad legs.
Oh, just look here.
The criminal case examined in this broadcast was videotaped under the direction of Eric F. Saltzman, a trial attorney and producer of Harvard Law School's Evidence Film Project. Mr. Saltzman arranged access to the trial and to the normally privileged discussions in the case. By agreement with all parties, the events and conversations witnessed by the production crew could not be divulged to the other side, nor made part of the trial evidence. Not every event or conversation was recorded. The unedited videotape was acquired by ABC News, and this broadcast was produced by Tom Bywaters and Mr. Saltzman. Charles Nesson, Associate Dean of Harvard Law School, was a consultant on the project. There will be profanity in this documentary. Parental discretion is advised.
What you are about to see has never been shown before on television. It is not just a criminal trial, which is only one part of our system of justice, but coverage of an entire criminal case. What you will view is a drama which in fact took place. 2 men whose lives hung in the balance, one paralyzed, facing possible death, the other facing possible imprisonment. 2 sets of lawyers in conflict, each intent on securing victory for its own side. We'll take you to the scene of the shooting, to the hospital bed where the victim lies helpless, to the county jail where the defendant and his lawyers plan defense strategy, and even to the conferences in the judges' chambers where critical decisions are made. And of course, we'll take you to the trial itself. What you will watch is an isolated case, but it is also a typical one which reflects some of the achievements and limitations of American justice today. You will see the lengths to which our adversary system goes to protect the rights of the accused. You'll see the emphasis on strategy and winning that adversary system has produced. And it may well be that you will ask, is justice done? Is the legal system we now have responsive to its basic task, to determine truth, to free the innocent, to convict the guilty? The program which follows is a journalistic summation of the actual case. Over 100 hours of tape have been reduced to 2. For purposes of clarity, some events have not been edited sequentially. We've tried not to interfere with the integrity of the legal process. All of the principals were aware of the cameras and consented to being photographed. Defense defense attorneys Sarah Lytle and David Allen meet with the defendant at the King County Jail in Seattle.
This is David Allen. He's the other attorney.
How do you do?
Seems like I saw you before.
I think I might have seen you out there before when I was here. Or maybe before a couple days ago. We've gone over your case a little bit. We don't know that much about it yet. We have the police reports, and we've skimmed through them, so we know a little bit about the case. And we'll be going over that with you maybe a little bit today, maybe not. Sarah, do you want to get some background information today?
Okay. I'm really kind of in a bind in terms of time, so we're not going to be up here for a long time today. But one thing that's important is that in terms of the way we proceed with this case, okay, and this is one of the reasons we don't want to talk to you about what's on the police reports until we've gone over them really carefully. Anything that you tell us about the case and about what happens, we're basically bound by that.
The only thing that I really don't understand is, you see, I don't quite know everything that I told the police.
Okay.
Because I was pretty well, you know.
I understand.
Yeah.
Well, anything like that is fine, because we understand that, from our experience and from just anything that we do from day to day, you don't always remember, and you try to reconstruct it, and it takes a while, and you remember one thing, then you think about it, and you remember other things, and we understand that.
Yeah, we're not talking about that kind of thing.
Okay?
Okay?
Well, I have it pretty clear most of what happened, you know. I've got that pretty clear.
All right, what kind of shape is he in now?
Okay, he's got the bullet entry site was in the jaw, so he's got a busted jaw.
At Harborview Hospital, prosecutor Dennis Nolet's investigation focuses on Big Man's condition. Will he survive? And if he will his testimony help convict Jones?
No problem. The bullet lies in under the skin on the left side, came in on the left side. It's now on the right side.
It's still there. Is there the possibility that he will die?
There is that possibility. With time, he's getting better. I would say the possibility right now is low.
It's a low possibility. Okay.
That he will die. That he will have significant impairment is rather high. Now, a problem with spinal cord injury is that these people frequently can have a psychosis. He may have mental status problems that may make the validity of statements made now, at least, subject to question.
Later on. I don't want to put him in any kind of danger at all. On the other hand, I want to win this case.
When did you see Big Man after that? He walks out the door. Did he come back in a little bit after that?
He come back for me.
What?
He come back for me.
What did he do?
Well, he come over to me, started over to me with his hand in his pocket, and I told him to get on away from him and leave me alone. And he kept coming, and I pulled the gun, and he stopped. And then I fired it, but I was trying to scam that time. And he stopped me, so I went back and sat down again. And then he come for me again, and that time he just kept on coming.
Okay, you scared him once, he went outside, he came back in. You fired another warning shot, then you shot him for keeps?
Yeah, shot him again. I shot again. Okay, but I didn't hit him the first, and you hit him the first time. That second time, you hit him then. But when I shot, but he kept messing with him, kept on coming after me, and so I shot him.
You understand who I am, Ray? All right, I'm the prosecutor. See, the problem is that we have to convict Mr. Jones from doing this. And it's going to be much easier to do that if you can try to remember back what happened that day, okay? And try to let us know what you said. Okay. Now, we know that you have a bad criminal record. I mean, you've been in trouble before, and some of that is going to probably come out on trial. So that the jury is going to know that you're kind of a rough guy sometimes. So that if that actually did happen that day, you might as well let me know about it now, because the jury's going to know about it later. If it happened. If it didn't happen, don't try to make up a story for me.
Do they have any idea, like, how imminent his demise is going to be?
The outlook for Big Man is grim. The outlook for Jack Jones, a possible 20 years to life in prison. Defense lawyers will be working closely with Melinda Eastman, an investigator in the Seattle Public Defender's Office. They review the evidence and begin to formulate strategy.
Our guy's living at the Terrace View Hotel. You know where that is?
Yeah.
You been there?
Yes. The T-View is a really dangerous place. It's where most of the drugs.
I ride my bicycle by every day.
Yes, yeah. It's a wonder you're still. It's where most of the drugs, street drugs, come out from Pioneer Square.
Okay, so you know the Terrace View Hotel.
I know the Terrace View.
Okay, and our guy was living there, and Big Man tried to rob him earlier, and our guy went up and got a gun and told Big Man to get out of there, and apparently fired a shot into the wall.
I think the witness, well, yeah, they say there were 3 shots fired altogether.
So
In any case, he chased him out for the first time with a gun.
And he said, "Get out of here and don't come back or I'll kill you." And he was good for his word, because when Big Man came back, he wasn't good for his word. He shot him in the head, but he said in the statement to the police that he intended to kill him.
He said he further advised the victim is a known drunk roller, strong-arm robber who commits these types of crime at the T-View Hotel.
And I think that's what we're going to have to do to win this case, to really show what type of individual he was, known as. And
so you're going to put the victim on trial.
So anybody we can find at the T-View who knows the victim as a drunk roller, strong-arm robber, etc. I think what we're going to have to try to develop, if possible, as far as the hotel is concerned, is to, and I'm not sure how we can do this exactly, but through witnesses or whatever, try to get across to the jury the reputation of the hotel, what goes on there, and just what the scene is there.
The lobby of the Terrace View Hotel, where the shooting occurred. To the residents here, Big Man was a familiar but an unwelcome figure.
You try everything. Don't listen to old Tex over there. He just raps off and on. See, that's the way we sit here. Every day. Every morning.
Come on
Bob gives us a few coins, to go eat on.
You can't tell what you said, man.
Yeah. Oh, man. This is what they call a skid row.
We
live in a blood and guts hotel,
We sit
a lot
here.
of guts to stay here, a lot of blood to spill, You know what I mean? I live here because I like living here. I get along. That's the only time I got in trouble was with the Big Man.
He ain't dead yet. One got the Big Man.
Oh, I hope to Christ he will die.
No, I wouldn't
There's
wish
a whole
that
lot
on
of people
anybody.
wish the same thing.
Do you know anything about Big Man?
Yeah.
I didn't like him too well. You don't know that. The man, he actually raped about 3 different women in this establishment. And they were Indian girls. A lot of these ladies that, Indian ladies that live in this hotel are hurt just as bad as she is. I mean, he's done wrong. You know what I mean, by plain rape.
I'll tell you.
He'll put a knife right up against your throat.
He'll rape them, then they're too scared to go and say that they got raped. But I'll tell them what he didn't. He raped me twice already. And he turned around and he said he was gonna go and break about it to my old man.
She's hurt bad. That's my little niece. Don't cry.
He pushed too many people, and everybody in this hotel knew it. And people have talked about it. They said, he's going to get it. And everybody said, I wish somebody would get him. I heard these words said. And as a part of it, who said it, I don't know. But anyway, it's been said over and over.
That guy just saved my life by Jack killing him because I would have killed him. Or one of us Indians would have.
Did you shoot somebody earlier that day?
No.
I thought you told the police that you shot somebody that morning, remember?
The defense has learned that Jones told police he shot another man before he shot Big Man.
Because the police seem to think that, well, okay, the reason I'm asking this is because the police took a statement from you. And in the statement you said that you shot somebody in the morning in the knee. Do you know anything about that? You do know something about that. Okay, why don't you tell us about it? Because we would rather hear from you than to have it come out the first time at trial. Okay?
This was, that happened 2 or 3 days earlier.
What happened?
Yeah, about the same.
They claim that you said that you shot the man earlier with the same gun you used to shoot Big Man with. You bought the gun a year ago for $75. You asked why you shot the man earlier, and you said the man had been pushing him around and you were protecting yourself.
Yeah, that's true.
Jam it in, guys. Jam it in.
You gotta look at this. Anywhere you look, a person's got to have a way of protecting himself. You know.
Jones talked about his situation with Eric Saltzman.
You gotta protect yourself and whatever you have. You gotta protect that. See, because I know first thing they holler, the law. All right. Now, okay. None of this would have happened if the law had been around. See, but law ain't no law there.
ABC News Close-Up will continue in a moment.
I'm going over to Seattle Police. I'll be there probably at 12 o'clock. 2 o'clock.
Prosecutor Nolet's first information on the case came from police reports.
All right, where is the videotape? Videotape's down.
An unusual piece of evidence exists, a videotape of Jones the police took soon after he was arrested.
Special investigations room down there on the 3rd floor of our building.
The defense attorneys have the right to examine all evidence in the state's possession, and they want to know early in the case what might help or hurt their client. One problem raised by the videotape was Jack Jones drunk at the time of the shooting. If the prosecution can prove that Jones shot Big Man not because he was afraid, but because he was drunk, this would hurt Jones' case. Being drunk is not a defense. Jack Jones admitted drinking half a pint of whiskey immediately after the shooting, but said he was not drunk before that.
That we can take care of.
Mr. Jones, I'm Officer Fogarty. As of this time, everything you say or do is being recorded on videotape. This recording will continue until I advise you otherwise.
Yes, I know that.
Okay, the time now, sir, is 20 minutes after 9 o'clock in the evening. The date is March the 9th, 1978. You're under arrest for suspicion of assault. Understand that? Okay, let me read you the right, sir. You have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to talk to a lawyer prior to any questioning and to have him present with you while you are being questioned. If you cannot afford to hire a lawyer, one will be furnished to you without charge before questioning if you wish one. Understand that, sir? Mr. Jones?
Yes, I understand. Yeah, I understand.
What I want you to do, sir, is I want you to do a series of tests in here for me, okay? Remind you that you are on tape.
Now, I don't know if I can do that. I got bad legs, see?
That's fine. I'm going to show you what I want you to do first, and then you could go ahead and follow me, okay? What I want you to do, sir, is follow this white tape. However, now every time you take a step, I want the heel and toe touch.
I can't do that.
Why not, sir? See, look at
I cannot do that because I got bad legs. I already told you that. I was trying.
Will you try?
I wouldn't want people who would tend to excuse a defendant's actions because he was drunk at the time. That's not a reason to let someone off for assault, but it is a reason that someone might think about, well, if he was drunk, he wouldn't have, and he's not that bad a guy, so let's not convict him. I want a conviction. I want this particular defendant and also this particular victim to get a message. I want society as a whole to get the message that, you know, you just don't shoot people.
Tell me how it came about that he took the money from you. Where were you sitting? Or where were you?
I was upstairs. When I come out the door, I met him in the hallway, and he said, wait a minute, I want to talk to you. So I stopped, and he said, what you got? I said, what do you mean?
Jones told police, as he's telling his lawyers here, that Big Man had robbed him less than an hour before the shooting. For the defense, this establishes fear in Jack's mind and supports his claim of self-defense. But for the prosecution, it suggests retaliation, not self-defense.
Did he grab you by the shoulder, by the neck?
Yeah.
Okay, what did he do? Did he squeeze your throat?
No, he had an arm around my neck.
Okay, so he got you in a headlock.
Yeah, and then he had one hand, he took the other hand, went in the pocket.
The state's investigation continues at the scene of the shooting. Detective Theodore Fonis takes Prosecutor Nolette through the Terrace View Hotel.
There's the case.
I think a considerable problem is where this took place. It took place at a hotel, which is an extremely run-down and smelly and seedy and unfortunate place, inhabited by largely by drunkards and sort of the dregs of society.
This is where the first bullet was fired, and they fixed the hole.
Yeah.
It's fresh plastic. Here's the bullet hole right there.
Most of our jurors will not be coming from places like that. They'll be coming from generally middle-class backgrounds.
Here's the other one that they were taking right here.
The one in the post, huh?
Yeah, that's that one that shows in that picture.
Right. This is the tile where the hat was found. Here's the photograph of the blood on the walls. Apparently some of that blood's been removed. Now some of it's still here. You can still see splatters of blood. Oh, from the TV set. From the TV set over to here. That's the measurement.
There will be, I think, a strong tendency for them to go, well, this is just another fight between drunks, and this guy is the victim because he got the worst of it, and this guy was charged because he got the better of it, and let's just throw up our hands and go home. That's something that might happen. As it happens, this is a grievous assault. This is not just a drunken brawl.
All right, so he was 13 feet away when he fired the shot. I assume.
Yeah, 12 feet, 10 inches.
All right, anything else I should look at?
Yeah, if you're satisfied, I'm satisfied.
As you know, our defense in this case is self-defense. okay? What we're saying then to the jury is that you shot at Big Man because you were afraid that he was going to hurt you seriously if you didn't, okay? One of the reasons that you were afraid of
April 24th, the defense has learned from Jones and other witnesses about Big Man's reputation for violence. This could be central to Jones' claim of self-defense.
Now, we have quite a few witnesses who can testify about things that Big Man has done to them or other people in the Ferris view, okay? It's important, though, that you already knew about these things before you shot Big Man. Now, first of all, there's a thing with DiCarlo where he had been stabbed.
Yeah.
Okay. And I assume that you already knew about that. Okay, you heard about the woman who was raped by Big Man also? And I think a lot of this stuff you had already told me before that you were aware of it. In fact, you're telling us about this as part of what led us to these witnesses. Okay? And I think that's as much as we'll discuss about those right now. Okay. And I'll go over the statement with you at some point, too. I don't think you've ever seen it, have you? The statement that they wrote out and had you sign. Okay, the important thing about the statement is that you didn't write out that statement. They wrote out that statement, okay? They say that they talked to you, they asked you a lot of questions, you told them a lot of things, and then they sat down and wrote out the statement, and then they asked you to read it over and sign it, okay? But obviously it wasn't in your handwriting, it wasn't in your words, and I'm sure that they put in the statement things that they thought would help them convict you, okay? So when you read over the statement, it's going to be important to think about what you actually said to them and what they may have written in there because they wanted it in there, okay?
I try not to be an obnoxious winner. I suppose nothing in particular happens. I'm relieved. I generally get sort of a good feeling about a jury because I think they've lived up to their trust. I think I'm a pretty good winner. There's always an element of tragedy involved with the conviction. There really is, and so I don't gloat about it.
Like you can take the most routine jury trial where you have the worst case. It seems like always by the end of the case we've talked ourselves into it, that we've convinced ourselves
that we're going to win.
There's so much ego involved in this stuff. It's incredible. And it's incredible around our office too. If somebody wins, there's hollering and clapping and their name goes up on the board with stars around it and fireworks, and it's wonderful. There's a lot of energy and it rewards winning. And losing is nothing. Losing is nowhere.
His condition could deteriorate. So it could go either way.
Big Man's condition remains critical. If he dies before trial, Jones will be tried for murder.
Is this guy going to croak or what?
Well, we're hoping, we have our fingers crossed that he doesn't.
No. He's not imminently going to die?
He's in critical condition. He's not going to live forever.
I understand that. What happened to him? Where did he catch it?
He caught it in the jaw.
In the jaw? And it went to his brain?
No, it went through to his spinal column.
All right.
And severed? Yeah, real.
I have a good time. I'll see you.
It's really tragic.
He can't move his mouth. He's not going to be able to.
Well, apparently he can.
Mark Lehman, chief felony attorney in the public defender's office, helps plan defense strategy.
What's going on with his brain?
Well,
I mean, because they can communicate with him, right, in some way. Like they'll say,
Morse code.
Will you show us the guy who killed you and he'll point his nose at the guy? Is that what's going to happen?
No, it's Morse code. He can move his finger.
No. What I'm asking is, like, he's not giving any statements to anybody, right? So he hasn't testified at all.
Well, there's something in there saying that they took a statement from, I don't see how the hell they could have, and I'm trying to figure out. We were supposed to go talk to a cop today. Yeah, Sanford there? What time will we be back tomorrow? Okay, thanks a lot. My name, Melinda. Yeah. Well, we're just talking about the case and trying to set things up.
For the defense, Jones' statement to police continues to be a major problem.
Now, the statement's a mixed bag. It's one of those things in a sense that it's not really completely inculpatory. It's not that bad. Yeah. We can live with it. Except where he talks about shooting another guy earlier that morning. Which is a problem.
You think they can get that in?
I don't see why not.
Was there such a shooting?
Yeah.
They have evidence of it.
Yeah, but the guy, it's really strange. The guy who was shot in the morning refuses to prosecute, which makes it sound like he was at fault, but it makes our guy sound just a little bit trigger-happy.
Well, it makes it sound like the guy is the... I mean, it could help you in your self-defense.
Why?
I mean, this guy's... We got his ass kicked that morning, and he had to defend himself then, and then later on in the day, this other guy's coming after him. He's completely beleaguered with people trying to waste him.
Yeah, that could be it partially.
If they can get it in.
Or it could be that this guy is the Liberty Valance of the T-View Hotel.
Has he got any priors?
Yeah, one for burglary, and as the prosecutor pointed out, he has about 13 misdemeanors. I don't know what they are yet.
Yeah, but if there aren't anything violent, what difference does it make?
Well, I don't think the priors hurt us. I think what hurts us is that he blew a guy away early. Didn't blow him away. He.
You better watch your stuff. What in the guy's statement is helpful?
I think the guy's statement that's helpful is that it's not clear that what he did was he chased the guy out of the hotel. As I see it, our guy, as it's sort of developing, our guy's the only guy with guts over there, or the only person with the guts to stand up to Big Man, who's the extortioner, the heavy over there.
Mm-hmm.
Comes in, and they throw him out all the time, and he still comes back. And our guy is the, if you want to say, the Gary Cooper.
How old is he?
Our guy, he's about 53.
That's good.
And he meets Big Man down in the lobby, fires a warning shot, and says, "Get out of here, and if you come back, I'll kill you." So it's conditional. But it's like throwing somebody out of your house. Supposing somebody comes in your house and assaults you.
The law is really good on the right you got to kick somebody out of your place.
Another problem we have, and this is just a slight one, is that the victim, when he came in, didn't have a knife in his hand. Though we all knew he had one in his pocket. And our witnesses are of the opinion that what the victim came back in the hotel for was to kill our guy, because our guy humiliated him in front of all.
You could probably sneak that out somehow.
Well, that's opinion testimony. Do you think our people can come in as experts?
Well, who cares about opinion testimony? The guy comes in, and you said, you have them testify something to the effect of, this guy came back to kill him. And once they said that, let them object all they want to. The hell with that. What they're testifying to is the reasonableness of your guy's apprehension. If they thought he was coming back to kill him, it's reasonable that your guy would think the same thing. I think that, they're allowed to testify to that under any circumstances.
I told him you were coming, and I think it's kind of up to you. You can talk. He cannot talk, so he's just going to be able to answer yes and no questions to you.
If he is able to talk, Big Man's testimony will be an important factor in the case. A witness has no obligation to talk to lawyers, but defense attorney Lytle wants to learn as much as possible about the prosecution case and what Big Man might say.
Is that enough? Do you need more air to talk? Okay, can you try talking?
Okay, first I want to tell you that I'm Sarah Lytle and this is Melinda Eastman. And we're both from the Public Defender's Office and we are representing Jack Jones, okay? I'm his lawyer and Melinda's the investigator who's working on the case, okay? Oops. You understand who we are? First thing that I'd like to ask you is if you could tell us what happened on the day that you got shot.
Why don't you get closer to me?
Maybe we could go, could we do yes or no without any help while you see if they can do that?
Go ahead.
So he can just nod or... Did you know Jack Jones? Statement from you? The police got a statement from you?
That's why you want a statement from me.
Oh, you want to know why we want one from you? Okay. Because we're representing Jack Jones. And he's charged with a crime. And we need to find out from you what happened so we can represent him. You understand that?
Say that again? Let you alone? That's good.
I think probably we should just let him alone and maybe... Could we come back and talk to you again some other time? No?
See if we will prosecute. Does anybody ask me that?
Do you want to prosecute Jack Jones? You do? Well, we're probably going to have to talk to you sometime then. Okay? Okay, but I think we better let him go for now.
You can swallow that, Ray. Try swallowing it. You can swallow it.
I just want a regular old deposition where his answers appear in black and white print on a piece of paper.
You know what the impact is going to be of this guy on videotape to a jury? No matter how mean an offer you make him sing, Sarah. I mean, there he is.
ABC News Close-Up will continue in a moment.
The prosecution must prove the defendant guilty beyond a reasonable doubt.
About the Jack Jones case, that assault in the first degree happened at the case.
A week before the trial, Prosecutor Nolet reviews the evidence with David Berner, Chief of the Criminal Division.
We're going to be able to get in that prior assault on the other guy earlier that day, aren't we?
Well, he doesn't want to come. He doesn't want to talk. He wouldn't give
the
a
victim
statement.
in that.
The victim of the prior assault. He wouldn't talk to the police.
I know at the time, but he's still taking that position?
Absolutely. Collins does have a record. It's part of it's in there. I've got a more recent printout here. He has a record, but it wasn't really assaultive until somewhat recently. He's got. Let's see, that's Jones.
Well, he does have a record.
But it's mostly the old stuff is drugs. There's a couple type larceny things, but I think they can paint Collins pretty bad.
Yeah. Yeah.
Alan meets with DeCarlo Myers, a resident of the Terrace View Hotel and an eyewitness subpoenaed by the prosecution. They talked about Big Man.
Well, I believe he was kind of like a pressure artist. You know, just the reputation alone that you know, he cuts people, you know, that gets in his way, you know.
Who does he cut?
Me.
When did that happen?
Well, this happened about 2 years ago, something like that.
Is that the scar you got on your chin?
Right.
How did that happen?
Well, we got in an argument. I was drinking down in the lobby. I guess he was drinking too. And he started calling family names and different things. And somebody told me he had a knife, you know. And I guess he figured, well, I was, you know, that I'd have backed off him. So anyway, we started to fight. He came down with his knife and he got me in the arm, stabbed me the other arm, and I think he cut me somewhere in the, I don't know if it was a knife, but when the ribs were. I fell back, somehow he got hooked to a wine bottle, and he busted me in the head with it. I had my cap on, and I fell back against the office. And then he took the bottle and he jabbed it, you know, at my throat. I wouldn't press charges because even though he called me all these names, I guess I initiated the fight, but as far as the knife can go, I didn't have a blade or nothing on me, but when I seen it, I just figured if me and him got in any confrontation again, I was gonna try to kill him.
Okay, was there anything in addition to what...
Myers meets with prosecutor Nolette. Although a key prosecution witness, Myers is a friend of the defendant Jones. Nolette reviews the statement Myers gave the police so he can be certain what Myers will say at the trial.
Do you want to take a look at it, and maybe you can let us know if there's any changes?
Yeah.
Would you like to do that? Let me get a copy of yours. It starts right here. Why don't you take a minute and go through it if you want. See if there's any changes that you'd want to make, and then we can go over it a little bit more closely if you want. Now, if you can think of anything that's different, that you remember differently now, or that you think the police wrote down wrong or something, just let me know and we can make the changes.
Here's something very good. After you shot the first shot at Big Man to throw him out, this is in DeCarlo's statement. Big Man came over to DeCarlo and put his hand on the edge of the TV and told DeCarlo, said to DeCarlo, "What's wrong with Jack?" This was just before you threw him out. You already fired the shot and told him to go out of there, but he hadn't left. And then I said, DeCarlo said, "I don't know." Jack came over there, and the only thing that DeCarlo could hear was, "You're not going to cut me like you cut Carl up." Do you remember saying that to Big Man? "You're not going to cut me like you cut Carl up"?
Yeah.
That's very important. Because the more that we can show the jury that you were afraid of getting cut that day, the better chance we'll have to show self-defense. In order to prove self-defense, we have to show that you were in fear of being killed. What we probably should do is to read to you the statement that you gave to the police.
Yeah.
So that you remember what they say you said to them. This was after you were arrested.
For the defense, Jones' statement is potentially devastating. It quotes him as admitting that he shot Big Man and intended to kill him. Jones claims he told the police that he was in fear for his life, but this does not appear in the statement.
Did you tell the police that you shot Big Man because he went through your pockets, or did you tell them something like, "I shot him because he was trying to kill me"?
That's what I told them.
"I shot him because he was trying to kill me"?
Yeah, I told them that because I told them when I come back downstairs with the gun that I didn't bother him until he come for me again.
You're sure you told him that? Because that's real important.
Yeah, I told him that.
Okay, let me just finish reading this and then we can go over it little by little, okay?
Jones' testimony in court will be crucial. During the weeks of discussions with his lawyers, Jones told them that Big Man carried a knife and that he had used it to cut up several people. Jones claims he did not shoot Big Man because Big Man had robbed him, but because he was afraid of him. This would be a legitimate cause for self-defense.
They're saying that you gave that statement and that you signed it. Do you remember if they ever read this back to you before you signed it?
Yeah, I remember reading it. Mm-hmm.
You remember hearing the same thing that Sarah told you?
Yeah, more so or less, I guess.
But that night, you didn't read this, did you?
No, I didn't even attempt to read it. He wrote it down. He had me talking, and he wrote it down. He was writing. I was talking, and he was writing.
You were assuming that he was writing down everything you were telling him, right?
And when I stopped talking, he'd ask something else. Keep on writing, whatever. And when he finished, he'd hand it to me and tell me to sign it right there. That's where it was.
Well, that stuff about you intending to kill Big Man and you went over to finish Big Man off, that stuff isn't true, is it?
No.
Were you just feeling real tired, like you just wanted to get it over with, just sign it and get them away from you? Is that
Right.
what you were doing? So
Yeah,
you
that was
didn't pay a
more.
lot of attention to what they were saying?
Right, yeah.
Jack, because there's some stuff in here that obviously isn't true and that, is going to hurt us if the jury believes you actually felt this. I was intending to kill him when I shot him. Well, that's okay, because when you're doing self-defense, you can use deadly force. This was for him going through my pockets. Well, from what you told me, that isn't why you shot him. You shot him because he was coming back in there to kill you.
Mm-hmm.
Is that right?
Mm-hmm.
So the correct statement would have been, you know, I was trying
to protect myself or something like
This
that.
was to protect myself.
Right.
The trial of Jack Jones, charged with assault with intent to commit murder, is almost ready to begin. The victim, Raymond Collins, some people call him Big Man, remains critically wounded in a Seattle hospital. Jones admitted shooting Big Man, but he claims it was self-defense. Lawyers for the defense and prosecution are about to have their first meeting with the trial judge. It will be his first contact with the case. In the privacy of the judge's chambers, each side presses for rulings favorable to its case on procedure and the admission of evidence. Here, critical decisions are made that could determine the outcome of the trial. What will be the ground rules for selecting the jury? And once the jury is selected, will the judge allow them to go to the Terrace View Hotel, the scene of the shooting? And will he allow them to hear evidence that Jack Jones had shot another man just a few days prior to the shooting of Big Man?
This is a self-defense issue, basically. And there's no dispute about the shooting.
No dispute about the shooting.
And you intend to use the statements in your case in chief?
Yes.
Okay, what else?
We have a motion in limine
On what aspect?
relating to an alleged prior shooting by our client.
I don't know, maybe the state doesn't plan to use these. We should ask Dennis first, I suppose.
Which one are you talking about?
We're talking about in the statement, he talks about shooting somebody else earlier. Or didn't you know about that?
I knew about that. Insofar as what's the motion?
Are you going to use that?
If I'm using his statement, if he talked about shooting somebody earlier that day, that's going to come out.
Well, he could talk about 73 things, and if they're not relevant to the case, they're not going to come in. Just because he said it in his statement doesn't mean they're admissible.
I suppose, they are relevant in a sense. It certainly would go to intent, the question of intent and his...
Brief it. When I see your brief, I'll rule on it. Don't bring it up in presence of the jury until you've asked. I'll grant the motion to eliminate to the extent that it won't be mentioned to the jury unless you bring it up in the absence of the jury and get a ruling on it.
Okay.
The other thing is we're going to ask that the jury be taken for a view of the scene, which would be relatively easy. We can probably just walk them up the hill or...
If we take them up, we'll take them up in a bus.
A bus?
All right.
Okay. We'd like to ask for a view of the scene.
Let me rule on that later after we put it in perspective. What is it, in the lobby of the Terrace View Hotel?
It's in the lobby of the Terrace View, and we feel that it's necessary for the jury to actually see it, to have a full understanding, especially since it's so close.
Okay. Well,
The defense wants the jury to go to the Terrace View Hotel so that the jurors can experience the violent climate there and perhaps better understand Jones' claim of self-defense. The judge wanted more time to consider that question. The defense was successful in excluding the evidence of the prior shooting. Judge Sokup ruled that it was not relevant because Jones was only on trial for the shooting of Big Man.
When a case is supposed to start, when the trial is supposed to start, they call down a whole bunch of people to the courtroom. I don't know exactly how many, but probably around 36 people arrive in the courtroom.
Please rise. The court is now in session. The Honorable David W. Sokup presiding.
Please be seated, ladies and gentlemen. Parties ready in case the state of Washington versus Jack Jones.
State's ready.
Defense is ready.
Call a jury, please.
307 Linda S. Post, P-O-S-T, 307 Linda S. Post.
Come on up here, will you please, Ms. Post?
.202 Geraldine D. Allen, A-L-L-E-N, 202 Geraldine D. Allen.
The clerk pulls out 12 names out of a hat, basically, of the 36 in the courtroom, and they all take their seats in the jury box, and there's 12 seats in the jury box.
Would all prospective jurors please stand?
Most people believe a trial begins when the first witness is called, but most lawyers will say that the case can be won or lost during pretrial hearings and other occasions for strategic advantage. Key among these is jury selection, where the lawyers attempt not only to choose sympathetic jurors, but with their questions, to indoctrinate them as well.
Do you have any strong feelings one way or the other about guns?
No.
Do you have any problems, or will you have any problems if the judge tells you that a person can use self-defense to protect themselves?
I don't think so.
You don't think you have any problems?
No.
Have you ever been in a situation where you've been afraid of another person?
No.
Do you think you can understand how that might feel?
Yes, I can understand that.
And do you feel that if the court so instructs you, you could try to see things through Mr. Jones's eyes at the time?
Yes, I believe I could.
Okay. Including taking into account all his prior experience, his prior knowledge, what he was feeling at the time, all those kinds of things?
Yes.
Even if those are very different than any life experience that you have?
Right.
It's often not easy to convict a person of a crime, even if the evidence is there. Do you think that you would have problems convicting a person of a crime, even if we presented evidence which convinced you beyond a reasonable doubt? Do you think that would be a hard thing for you to do, even if the evidence satisfied you?
I think I'm able to keep an open mind.
Okay, but do you think you'd be strong enough to look at Mr. Jones and tell him he was guilty if you were satisfied that he was?
I felt that he was, yeah.
Mr. Nolet asked you a question, and I'm going to ask you a related question. If the evidence showed that someone was badly injured, but you felt the state had not proved the charge beyond a reasonable doubt, could you return a verdict of not guilty?
That he was, yeah.
The thing's ultimately going to come down to what the jury decides.
Yes, I suppose so.
What kind of people would you like to see on the jury if you had your choice?
Well, I wouldn't like to see I wouldn't like to see older people, more so church people. I'd like to see people that know a little something about, like, what it's like to be out here in the streets alone and things, something like that. I'd like to see somebody like that on the jury, you know, that's been around, that know and seen things happen, or read about things happening, know how they happen, know of how they happen, and so forth like that. Not just somebody just to come up and say, well, I think he's guilty, or I think he's innocent. Somebody that would have some kind of background on the edge of that, you know, more so like that. That's what I think would make the best jury.
ABC News Close-Up will continue in a moment.
Ninety 90% of the criminal cases filed never go to trial. Many are disposed of through plea bargaining. Defendants plead guilty in exchange for reduced charges or lesser penalties. In the Jones case, no deal was made.
I think they'll convict him. I don't have any doubt about that. I don't think any jury is going to decide that it was okay under these circumstances for him to put a bullet in this guy's neck. And that's the bottom line.
It's our job to give our client the best defense so that the judge or the jury will come to the right decision, and that's justice. I feel we're going to win this case right now. I know we're going to win it. But if he's convicted, a great injustice will be done as far as both of us are concerned.
Please be seated, ladies and gentlemen. I call your first witness, Mr. Hall.
If it please the court,
The first witness for the prosecution is a resident of the Terrace View Hotel, Connie Gardner.
When was the first time on March 9th of this year that you saw Mr. Jones?
It was early in the evening.
About what time?
I guess about 6:30 or so.
All right. Did you hear what they were arguing about?
No, I could hear Jack mostly,
And what was Jack saying?
like word for word.
Well, are you saying there were some unpleasant words used?
Well, obscenities.
All right, go ahead and tell us what, as far as you can remember, what was said.
Well, 2 or 3 times I heard Jack state to Raymond, "Stop fucking with me."
He said that?
Yes.
What was Mr. Jones doing when you saw him standing there in the opening?
When I turned around, he had the gun up in the air, aiming it.
Okay, and aiming it at what? Could you tell?
I couldn't see.
Pointing off in this direction?
Yes.
Okay. And you couldn't see what he was pointing at?
No.
What happened after you saw that?
It all happened so fast. I heard the shot, and I heard something drop, and everybody started screaming and running in every which direction.
The prosecution hopes that Miss Gardner will testify that immediately before the shooting, Jones said that he might end up in jail that night, evidence which could establish premeditation.
And I could see Big Man lying on the floor.
Do you remember seeing Jack do anything with his hotel key?
Yes.
When was that?
That was before Mr. Collins came back in the door.
And this was before the shots were fired at Mr. Collins?
Yes.
What did you observe at that time?
Well, he handed the keys to a man they call Willie Caldwell.
Willie Caldwell?
Yes.
What did he say?
He kind of pushed them onto Mr. Caldwell and told him to take the keys. That I can't remember the exact words now, but words to the effect that he would like him to take care of his room, because if the man come back, he would end up in jail before the night was over.
Okay, I have no further questions. Thank you, Ms. Gardner.
At the time that Big Man came back into the hotel, you thought he would cut Jack up if Jack didn't shoot him, didn't you?
In my opinion, if Jack had not had the gun, he definitely would have retaliated.
Big Man?
Yes.
No further questions. Thank you.
Connie did not hurt us, and she helped us a lot. Because in her statement, she was saying some weird things, and when we talked to her, she said some weird things. And when she got up on the stand, it made it very clear, at least to me, what I heard her saying was that you and Big Man had an argument. You told Big Man to get out. It was clear to Big Man he was supposed to get out. Big Man came back in, and he was trying to get you, especially when she said Big Man would have cut you if you didn't have the gun.
But now, she says I jumped up when I saw Big Man. I jumped up and went running towards him. I wasn't doing that because I'm scared of the man. How in the hell I'm going to run to him?
So how long did this argument continue?
DeCarlo Myers will testify for the prosecution that Jones did shoot Big Man. But Myers will also help the defense by saying that he himself had been assaulted by Big Man.
What happened to end this discussion as it happened at that time?
Big Man was shot.
He was what?
Shot.
Did you see Mr. Collins?
Yes, I did.
Did he appear alive?
Yes.
Was he saying anything?
No.
Was he bleeding?
Yeah, I seen a little blood.
A lot of blood, in fact. Isn't that true?
A little blood.
I have no further questions.
Mr. Myers, was the statement that Jack made to Big Man, "You're not going to cut me like you cut DeCarlo"?
That's correct.
Had you been cut by Big Man?
Yes, I have.
What did he cut you with?
At the time, I don't know if it was a knife or a bottle. I believe it was a bottle.
And where did he cut you? Do you have a scar there?
Yes, I do.
Did you tell Jack Jones about the fact that you had been cut by Big Man?
Yes, I did.
Thank you. No further questions.
I call you next witness.
The prosecutor calls Detective George Marburg.
Raise your right hand. You solemnly swear the testimony that you're about to give in this case will be the truth, so help you God.
At issue is the incriminating statement Jones gave to the police.
Did Mr. Jones, in fact, make a statement?
Yes.
What was the procedure followed in taking down Mr. Jones' statement?
First, we told him what he had been arrested for, what he had been accused of. He had first denied that he had shot anyone, denied even owning a gun. We told him that we had spoken with a person that had told us differently. And he asked if he could think about it for a minute, and so he did. He sat there for a minute and a half to 2 minutes or so, and obviously thinking about something. And then he said, I shot the motherfucker and I intended to kill him.
You give him the opportunity to make any changes or corrections to the written statement?
Yes.
Did he make any changes or corrections?
No, not that I recall.
And after he reviewed the form, did he sign it?
Yes.
Did you make any threats or any promises to Mr. Jones?
No.
Any kind of coercive tactics used in getting this statement?
No, as a matter of fact, he had, after we finished it, he commented to us that how kind we were to him.
I have no further questions. Thank you, Detective.
You indicated that you wrote out this statement.
Yes.
Is that correct?
Yes.
Mr. Jones didn't write out any of this. The most that he did was sign his name on the statement.
Yes.
And you wrote out the statement in your own words, did you not? I mean, you were trying to basically interpret what he was telling you, but you put it in your own words, didn't you?
No, I'm not. Mr. Jones told him, answered the questions. He told us what happened, and we tried to put it down as closely as possible in his words.
Okay,
Now,
well,
I can't say exactly in his words, but I'm saying regarding the incident itself, we did not put words in his mouth, and we didn't put anything on that paper that didn't happen.
Okay, what I'm talking about is the manner of speaking in the statement. I mean, this isn't Mr. Jones's manner of speaking, is it? It's the way
That
this is written.
statement represents, regarding the incident, basically what Mr. Jones told us.
Okay, but put into your words.
It's my printing on the statement.
Okay. But it's not word for word his words.
Mr. Jones did not print the statement. I printed the statement.
Okay. Now, you didn't tape record the interview that you had with Mr. Jones, did
No.
you? Obviously, if the interview had been tape recorded, we would know word for word what Mr. Jones said to you during that hour or so that you talked to him, wouldn't we?
I would think so.
But it wasn't convenient for you to tape record the interview with Mr. Jones.
I was careful in how that statement was taken.
Thank you. I have no further questions.
Did you have him in your own custody at that time?
Although a prosecution witness, the testimony of arresting officer Thomas Pritchard establishes that Jones did tell police he shot Big Man out of fear.
And did Mr. Jones say anything in particular to you or have any comments to make during the time that he was being transported to jail?
The only comment he made was the reason why he had shot Mr. He called him Big Man was because apparently they had a disagreement over, I wasn't clear what the reason was. Mr. Jones indicated he was afraid that the victim or Big Man would hurt him. So.
True, is it not, that what he said generally was, I had to shoot him because I was afraid he was going to beat me up or hurt me, something of that
Correct.
general nature. Did he just make that general statement, or did he go into great detail about what he meant?
He didn't go into great detail. He made the statement, and then he qualified it by saying he was much smaller than our victim was, and he was afraid of him.
Take a 15-minute recess. Please remember our advice about not discussing the case, ladies and gentlemen. You can be recessed.
The prosecution's next witness is Raymond Collins, Big Man. Unable to appear in court, his testimony was videotaped at the hospital. Viewing the tape in chambers, Judge Sokup will decide whether the jury will see it. The prosecution wants the tape admitted.
Is that in a hotel? Right. What's the hotel? Miss Nolet, that you want the jury.
Out of the presence of the jury, the defense argues that Collins' testimony be admitted in writing only.
Position on that. vital, Mr. Allen?
We object to the use of the video portion of the deposition. We feel if the prosecutor wants to use the video to arouse the sympathy of the jurors, there's no other reason whatsoever to do that. The video shows wires attached to Mr. Collins. It shows a tube coming out of his neck. It shows an air pump which has to be used before he can talk. It shows a nurse standing by his bedside. You could hear some of the machines operating during the course of the video. It's not necessary for the jury to be shown a videotape which will do nothing more than arouse their sympathy and prejudice them against Mr. Jones.
I'm going to let them see the tape. I don't see how a jury could put the testimony of the witness in proper perspective in any other fashion.
Well, I would note our objection, our strenuous objection.
Okay. Strenuous objection is noted.
Later that day, the jury did see the tape of Big Man's testimony.
Ray, now just for the record, would you tell us what your name is?
Warren Garner.
And do you remember being shot on March 9th, 1978? Who was it that shot you?
Jack. The guy called Go Jack.
Jack? And is his last name Jones? Was there any kind of fight or trouble with Mr. Jones?
No, it wasn't no fight in that. And I ain't giving him no cause for no fight in that because I don't mean him and no words.
Did you ever threaten Mr. Jones?
No.
Did you have a weapon with you the night of March 9th?
A small knife.
You had a small knife? Did you ever open the blade or threaten Mr. Jones with it?
No.
Did you ever threaten Mr. Jones in any way on March 9th?
No, I didn't.
Okay, that's all the questions I have for now, Mr. Collins. Now, Mr. Allen's going to get a chance to talk with you, okay?
Mr. Collins, my name's David Allen. Can you hear me okay?
Yeah.
Have you ever been convicted of a crime?
Yeah.
What crime is that?
Well, I ain't that close to that. I've been convicted.
What's that?
I ain't that close. I've been convicted.
He said, I don't have to discuss what that was for, but I've been convicted. Is that what you said, Rick?
Yeah.
Yeah, you do have to discuss, and I'd like you to tell me what you've been convicted of.
Oh, mostly drugs.
Drugs?
Mostly drugs.
Were you convicted of forgery in California in 1959?
Yeah.
Yes. And did you get a year in jail?
Yeah.
And were you convicted of burglary in California in 1960?
Yeah.
Thank you very much, Mr. Collins. No further questions.
Okay.
Yes, thank you.
Please rise. Court is in session.
Morning. Be seated again, please. Rise the jury.
Yes, we are, Your Honor. There's only one matter. We've previously asked for a view of the scene, and we didn't know when you wanted to take that up because arrangements might have to be made, so we'll just bring that to your attention that...
Oh, you want to take that up now? It's fine.
If you want to. We feel very strongly, as we said before, that a view of the scene is necessary. I can perhaps best talk from my own experience. I went up there this morning and took a look again in the lobby. I think it's real important because the key factor here is going to be how close was Big Man to Jack, how reasonable was Jack's apprehension. Of course, Jack is going to testify in this case. We've already told the jury in our opening statement that he acted upon a reasonable apprehension that he had to shoot in order to protect himself. So for that reason, we'd be asking for a view of the scene.
Ms. Nolley?
Your Honor, I'm not opposed to a view of the scene. I just think it's unnecessary. I don't know that there's anything about that outer lobby that's really noteworthy. I've been there myself. I don't know that seeing the area adds anything to the jury's understanding of what the room dimensions consist of. Perhaps it gives them a better flavor of the seediness of the place. But again, that's something that can be brought out in testimony, and I just see no purpose to do it.
Make arrangements to have a bus at the 4th Avenue entrance to the courthouse at 1:30. Also advise the manager that we like please to have him clear the lobby of all individuals so that there's no one in either lobby area at 1:30 or shortly thereafter when we arrive.
The defense may have had other reasons for wanting this middle-class, all-white jury to visit the Terrace View Hotel. The jurors might be shocked and frightened while inside the hotel, and more readily accept Jack Jones' claim that he shot Big Man out of fear for his own life.
We're gonna. Hey, you niggas got no business coming in. We're gonna go slowly through the places that are relevant. The trial will be held up by Linda. Get out of here. Say, man, you take your camera, man. You're not gonna do this shit. That's right. Just like say, man, get that camera out.
Several of the Terrace View residents were subpoenaed by the defense to testify about Big Man's prior acts of violence. But Judge Sokup did not allow that testimony. He concluded that Jones was not aware of all these acts of violence when he shot Big Man, and so they did not necessarily contribute to his fear or support his claim of self-defense.
Okay, when Big Man came back into the hotel, what was he doing when he came back into the hotel?
Coming towards me, but the way it looked like he was getting close to Carl. See, that's why I come all the way out so I could keep him from getting Carl between me and him. Cause what I was thinking, he planned to push Carl into me so he could get to me.
Well, the same thing that Carl was afraid of too.
So
did he have his knife out?
No, but he just had his hand in his pocket.
Okay, and you fired a warning shot.
Right.
Did you intentionally try to miss him?
I meant to miss him. I did miss him.
What Jones had really intended to do that night at the Terrace View Hotel is central to his defense. Did he intend to kill Big Man? Connie Gardner contended he said he did, and the police statement quotes Jones as saying he did. But his defense is based on the contention that he did not intend to kill, or at least not until he felt his own life threatened. And after repeated conversations on the issue between Jones and his attorneys, they continue to go over that point.
During this period of time, did you want to kill Big Man? No. Okay, don't even think about that. I mean, it's so clear to me. I know the answer, and I wasn't even there. You know, when he asks you tomorrow, or we ask you tomorrow, we say, did you intend to kill Big Man before all this? And you go, well, let me think. You know, forget it. I'm going to get a towel out of my briefcase. I'm going to throw it right in the middle of the courtroom.
Okay, now.
All you wanted to do was get him away from you.
Right.
Okay, let me try that again. When you marched him out of the hotel, when you shot through that post and you marched him out of the hotel, did you intend to kill him at that point?
No.
Okay, no, I didn't.
No, I didn't. Because see, if I was intending to kill him, I would have killed him over here.
Okay, Jack, that's what you got to tell the jury.
Okay.
I think that's good when he explains it like that.
That's what I'm trying to get. That's what I'm trying to get around to learning. Is the how to
It's hard to
express it.
express how you felt, but it's real important that you do the best you can. If you meant to kill him, you could have killed him right there. And it's important you try to explain what you're feeling to the jury.
You solemnly swear the testimony that you're about to give in this case will be the truth, so help you God. Please come up, sir.
Could you state your name, please, and spell your last name?
Jack
Jones, Jones.
Do you remember saying anything to Willie Caldwell about your keys?
Yes.
Okay, what did you say to him?
I told him to take the keys because if he came back in there to bother me, I was going to be in trouble.
What were you thinking about when you said that?
Well, I was thinking if I let him get to me, he'd probably kill me or something. And so the only way I could stop him was with the gun.
Now, up to that point, had you at any time intended to kill Big Man?
No.
Okay. And what was your intent with the gun?
To stop him.
When you saw Big Man coming into the hotel, could you see what his expression was, what the expression on his face was?
I could see that he was angry.
Okay. So what did you do then?
I told him not to come over there any further. He stopped after I fired. He kept walking until after I fired.
It was the second shot then. Okay. And why were you firing that shot?
To scare him off again.
And at that point, could you see the expression on his face?
Oh, yes, he was furious then.
Were you able to see where Big Man had his hands?
In his pocket. One.
One in his pocket?
One in his pocket, one was out.
And what did that mean to you?
That meant the knife to me.
Did you say anything to Big Man then?
I told him to stop.
Okay, did you say anything to him about DeCarlo?
I told him he wasn't going to cut me up like he did to Carlo. But that was, when I said that, I fired then. Because I was scared he'd get to me and hurt me bad, man.
In this discussion, the night before Jones testified, Sarah Lytle questions him on his intent and reassures him on his choice of words.
Did you intend to kill him at that point?
I also intended to stop him, I think.
Okay, you didn't think about it specifically?
No, I didn't think of killing him. I don't know what well, naturally you get a little mad when things
But
are
you were
over.
ready to kill him if you had to, weren't you?
Yes, I think so, I guess so. Sure, I'm sure of it. Yeah, I probably would have.
Okay, when I asked, did you intend to kill him at that point, you could say, I most just intended to stop him. I wasn't thinking about trying to kill him.
I intended to stop it.
Okay.
At that point, I meant to stop it.
All right.
See, the other times I didn't intend to hit him, but that time I meant to hit him because I didn't know exactly how many bullets I had left, or I know I'd be in trouble if I ran out of bullets.
You remember talking to the police when they arrested you, don't you?
Yes,
Okay. And did they take you downtown?
yes.
Do you remember ever, or do you remember at that point saying anything to the detective like, yeah, I shot the motherfucker and I intended to kill him?
No, I don't recall, but I wouldn't say I said it. I wouldn't say I didn't.
Okay, what did you tell them about why you shot him?
I told him I shot him because I was scared he was going to kill me. I don't think they put that in the statement.
Did you notice it wasn't in the statement at the time they read it to you?
Yeah.
Did you say anything about it?
No.
You just want to get it over with?
Yeah.
The most dangerous aspect of a defendant's decision to testify is that he must ultimately face the prosecutor's cross-examination.
First thing, I just want to remind you, don't guess about any of your answers, okay?
Right.
If you don't know, say you don't know. If you don't understand the question, say you don't understand the question. All right? The prosecutor's going to probably come down on you on the statement. He's probably going to come down on you for things that the officer said you said in the lobby. And I think David basically went over all the things. And it's just real important. Every time you get a chance with the prosecutor, every time he allows you to say it again. I was really afraid of the guy. I thought he was going to cut me up. I knew he had a knife. Those are the important things. And, if the prosecutor gives you a chance to say them again, then do.
And when he came back in that door,
You stood up.
Right.
And you walked towards him, didn't you?
Yeah, I guess so.
And you had your gun out.
Yeah, I took it out when he come in the door.
He didn't have a gun in his hand, did he?
I don't know what he had in his hand. He had his right hand in his pocket.
Right, but you didn't see a gun.
No.
You didn't see a knife.
No, I didn't see anything.
So you decided he was coming after you.
I didn't decide anything. I thought so.
You thought so?
Right.
All right. In your own head, you made up your mind that he was coming after you.
In my own head, I was scared.
And Mr. Collins never displayed any sort of weapon. Isn't that right?
Yeah.
And the only thing Mr. Collins did to make you scared was walk in the front door. Isn't that right?
At that point, yeah.
You were pointing that gun more or less right at him when you fired that second shot.
I'd say no.
You'd say no.
Right.
Okay. But the third time, you were aiming to kill him. Isn't that right?
I intended to stop him the third time.
You intended to kill him. Isn't that correct?
I'd say I was intending to stop him.
Would you say that you intended to kill him?
I object. He's already answered that
He
question.
has not answered.
Overruled. Let me answer. Go ahead, Mr. Jones. You can answer that question. Answer the question, please.
Would you like me to say it again?
I thought I already did answer.
Let me try one more time.
Okay.
When you fired that third shot, you intended to kill Mr. Collins, didn't you?
No, I intended to stop him.
You didn't want to kill him.
I want to kill nobody, no.
You just wanted to wound him. Is that right?
Whatever it took to stop him.
Whatever it took to stop him. Huh?
Right.
And that's why you shot him in the face.
Frankly, I didn't know I was going to hit him in the face.
You aimed for his face?
No.
What were you aiming for?
I didn't aim at all.
You just put the gun up and went bang.
I didn't put the gun up. I had the gun up.
How much had you been drinking?
Oh, I'd had a few drinks, but if you mean if I wouldn't say I wasn't out of my head of anything, no.
Nothing like that?
No.
The alcohol didn't have any effect on your memory?
No.
Didn't have any effect on your aim then either?
No.
The bullets pretty much went where you wanted them to go?
True.
Okay. Do you remember the statement you gave to the police?
Yes, I remember some of what I said, some of it I don't.
Do you remember telling the police that you went over to him to make certain that he was dead?
I know he wasn't dead.
Do you remember telling the police that you went over to him to make certain that he was dead?
I don't guess so. I don't think so.
Would you like to review the statement?
Which one?
That you gave to the police?
Oh, they wrote it. I talked to them.
Could you have said, I shot the motherfucker and I was trying to kill him?
It's possible.
I have no further questions.
Since this is a criminal case, all 12 of you must agree for you to return a verdict.
Before the lawyers present their closing arguments, the judge defines the law by which the jury must decide the case. Jack Jones is charged with assault in the first degree, assault with intent to commit murder. He can also be found guilty of second-degree assault, which does not involve intent to kill. Judge Sokup tells the jury to find Jones not guilty if they conclude that he shot Big Man because he feared death or serious injury, as long as Jones' fear was reasonable.
For all of the evidence, you now know what the law is, but you have not yet heard the arguments of counsel, and it still is not proper for you to try to make a decision to discuss the case with others or with yourselves.
Is it possible to shoot someone in the face not intending to kill them? And I asked the defendant, I said, is it possible that your drinking had some effect on your aim? No. I said, well, did the bullets go where you wanted them to go? He said, yes. There would seem to be no real question as to what Jack Jones wanted to do when he shot at Raymond Collins. What were his first words to the detectives? I shot the motherfucker and I intended to kill him. Those words are the defendant's. You can rely on it. And that's what happened. After he fired that third bullet, he walked over to make certain that Raymond Collins was dead. And he satisfied himself that he was. And that's when he dropped the gun and went back and sat down, because the deed was over. If he ever had anything to worry about before, he knew he didn't have anything to worry about now. There is proof beyond any shadow of a doubt that when defendant fired that bullet into Raymond Collins, he meant it to kill him. Was it reasonable for Jack Jones to shoot Raymond Collins with the intent to kill him? Was it reasonable to try to kill Raymond Collins? Based on the information that you have in this case, was it reasonable for Jack Jones to try to kill Raymond Collins? No. Was Jack Jones' life threatened? It was not. Is there any evidence that Mr. Collins intended death to Mr. Jones? No. Is there any evidence that Mr. Collins intended to assault or hurt Mr. Jones? None. The state has met the burden in this case. There are 4 things which we must prove to you, and we have done it. We have proved to you beyond a reasonable doubt that the defendant assaulted Raymond Collins, and we have proved to you that that assault was unlawful. We have proved to you that this assault was committed with a firearm. We have proved to you that the defendant acted with the intent to kill Raymond Collins. And I urge you to act on that evidence and find this defendant guilty of assault in the first degree.
You're looking out Jack's eyes when this is happening. You tell Big Man to get out of the hotel because you were robbed. And then you're waiting there, you're sitting there, and you see Big Man coming back, and you see it from Jack's eyes, and you see what happens, and you see somebody coming in 5 inches taller than you are, 50 pounds heavier, looking mad. You'd be scared to death. And if you were Jack Jones, knowing everything Jack Jones did when he was standing there, you would think that Big Man were coming towards you and was going to cut you. And that means death, possibly. It means disfigurement and death, and you're going to protect yourself in a reasonable way, and at that point, the reasonable way is to shoot him. Jack did the only reasonable thing that any reasonable person would have done at that time, and that's self-defense. And that's not guilty.
Unable to make bail, Jack Jones has spent 2 months in the county jail. If Jones is convicted, prosecutor Dennis Nolet will recommend a sentence of up to 20 years to life in the state prison.
I know what he's doing. He's working as hard as possible to try to build his case up against me as much as possible, you know. In other words, he want a verdict, guilt, first degree, that thing. That's what he doing. I know what he doing.
We got traffic jam, so have this train back up over here.
Hard waiting for anything. You don't know how long, what's going to happen when the day finally do, you know. Yeah. You're always wondering what that day going to bring. The only thing I can do is just hope for the best. Might be good, might be bad. You never know.
ABC News Close-Up will continue in a moment.
Well, I happen to really like Jack Jones. And I know I'll be really devastated if we lose the case. And of course, it's happened to me before. It wouldn't be the first time. You know, it's a very heavy thing during those days to try to pull yourself together and realize that, you know, it's not the end of the world. I mean, in one sense, I think Jack would survive in prison, because obviously he's going to go to prison if we lose the case. I mean, he survived at the terrace view. Prison can't be that much worse. But, you know, in another sense, he just doesn't deserve to be there. And I'll feel really terrible if he goes there, and I don't think that that should be the verdict. And I'll feel like we failed if they find him guilty.
I just find it impossible to believe that a jury would acquit him. On the other hand, juries are people. How they're going to go about analyzing the evidence, how they're going to assess the fact that our victim is probably as bad a person as the defendant is, all things considered, in terms of previous behaviors. How they're going to add it all up, I just don't know.
The charges that were submitted to him, one is assault in the first degree and the one is the assault in the second degree. So even if they find you not guilty of assault in the first degree, they can still find you guilty of assault in the second degree. So wait until they're done reading everything. Okay, and then we'll explain to you what it all
Good to see you, ladies and gentlemen. Has the jury reached a verdict in the case, sir?
Yes, sir.
Would you hand the verdict to the bailiff, please, Mr.
We, the jury, in the above entitled cause, do find the defendant, Jack Jones, not guilty of the crime of assault in the first degree as charged. Verdict Form B. We, the jury, in the above entitled cause, do find the defendant, Jack Jones, not guilty of the crime of assault in the second degree as charged.
I want to thank all of you for the time that you've devoted to considering this case, and those of you who are now completing your service, I want to thank you for completing the 2 weeks of jury service that you have given. Mr. Jones is discharged from custody by order of the court.
Thank you.
We'll be at recess.
Handcuffs now, Jack. Hey, that's wonderful. Okay.
Good night. I'll call you on Monday. We got it.
Okay, good.
When he got close to me, I was in fear of my life.
You think that he got justice or what?
I think he got better than justice.
Who's that?
Big man. I don't know what's going to happen with him. And as a matter of fact, I don't care. I don't care if he live or die. Me, I don't care. It's a material to me. I don't never want to see the person no more because if we have a conflict again, if I get the opportunity, I definitely will kill him. I definitely will.
A month after the trial, Jack Jones was assaulted and robbed at the Terrace View Hotel. 2 weeks later, Ray Big Man Collins died at Harborview Hospital. We've just seen a criminal case in which the defendant, Jack Jones, is found not guilty. And after that verdict, the victim, Raymond Collins, dies. I'm here with Professor Charles Nesson, an associate dean of the Harvard Law School, who, with his colleague, Eric Saltzman, was responsible for the unique access to and taping of this case. Professor Nesson, just how typical was this case, and how would you evaluate the way it was handled?
Well, I think it was quite typical. You had a criminal incident that was violent, somewhat drunken, had a very serious charge with very serious potential penalties. That's the grist of the typical criminal trial. In some other respects, I think it may not have been so typical. The case, in fact, was well handled by the defense counsel. The judge was decisive, intelligent, knew the law. The prosecutor paid attention. He took the case seriously. Unfortunately, that may not be so typical in many places. Finally, the Seattle system worked very efficiently, unlike many big city systems. One of the considerations that I think is most important about this program is that viewers not leave it with the idea that they sometimes leave television dramas with, and that's that the defendant is either clearly guilty or clearly innocent. That's not real life. In real life, things are much more complicated, and the trial system is built to deal with real life. What the jury found in this case was that Jack Jones was not guilty. They didn't say he was innocent, and that's a very important distinction. What they found was that the prosecution hadn't proved beyond a reasonable doubt that Jack Jones was guilty, and that's all.
Explain, if you would, why important evidence like Jack shooting another man was withheld from the jury.
Well, it's a close question. The court had enough trouble dealing with the shooting of Big Man. Now, what you're talking about is an incident that took place in Jack Jones's life with another person on another day. It might seem relevant in the sense that depending on just what happened at that prior incident, we might think that Jack was a little more trigger-happy, a little less trigger-happy. But the system has enough trouble dealing with one incident at a time, and it makes a balance. It focuses on the event that's the subject of charge and leaves those other events to other prosecutions.
Do you think our adversary system is more concerned with winning than it is with justice?
For some of the trial participants, it surely is. For the defendant, he wants to win. The defense counsel want to win within the bounds of law. The prosecutor wants to win. But the architects of the system assume that all those things are true. They assume that the adversaries, well prepared, will present their case in front of an impartial jury, try and poke holes in the other person's case, and that out of it will come a judgment by people like you or me as to what's fair in the system, what's justice. And I think we had a pretty good shot at that in this case.
What about this coaching, preparing the witness for his testimony? Isn't that a delicate process? Where would you draw the line on something like that?
The line is a fine one. A defense lawyer cannot tell a defendant what story he is supposed to tell. He can't help him construct a story. But he is obligated to take the story the defendant tells him and help the defendant tell it as effectively as he possibly can to that jury. Jack Jones here is an indigent black man caught up in a judicial system that's basically white, in which words are very important. It's a system that's foreign to him, and his lawyers can help him deal with that system. Indeed, they're obligated to help him deal with that system.
Do you see excessive coaching where lawyers wind up putting the story in the defendant's mouth as a problem for the legal profession?
I think it's more a problem for each individual lawyer than it is for the profession as a whole. And that's because these kinds of sessions in which a witness or a defendant is prepared take place normally without cameras present, without anybody, in fact, present except the lawyer and the client. So that if a lawyer goes over the line, there's no real sanction to it. On the one hand, you have a lawyer's very strong motivation to win a case. Indeed, he's obliged to try and win the case. And on the other hand, you have his sense of personal ethics. You have his sense of obligation to the court system as an officer of the court. It's a decision that each lawyer has got to come to terms with himself.
You feel most lawyers stay on the right side of the line?
My sense of the ethics of the criminal bar, mixed. Some do, some don't. In this case, I think these lawyers did an excellent job.
And of course, now the verdict is in, and it's not guilty. Jones is free, and even though Big Man has died, the case is closed.
That's true. Had the prosecution waited until after Big Man died, they might have tried Jack Jones for murder. But as it was, they proceeded before he died, and the double jeopardy clause of the Constitution dictates that the state get only one crack at a defendant with respect to a particular event. They took their crack at Jack Jones here, and they lost. When that jury came in with its verdict of not guilty, Jack Jones is a free man. And as far as the court system is concerned, perhaps as far as Jack Jones was concerned, it no longer made any difference whether Big Man lived or died.
It is traditional for lawyers to learn their craft through intensive examination of first one case, then another. Tonight we've shown you just one case, the state of Washington versus Jack Jones. That case is now closed. But through it, perhaps you may have seen some of the complexities and limitations, some of the achievements and aspirations of American justice. Our thanks to Professor Nesson. I'm Tim O'Brien, ABC News. Good night.